slowly trickling in, so we're going to get started to avoid the high 6-minute fees from Matt and Steven. So for those of you who are here, welcome to the Founder Issues and Legalities session. If that's what you're here for, you are in the right place. Moving forward, our agenda for today, we're going to spend a bit of time just providing a introduction to the Mississauga Business Entrepreneur Center, just briefly, and then talk about this Scale Up series. This is the first session of our exciting new Scale Up series, so I'll provide a bit of information about that. And then I will introduce you all to our speakers, Brenda, Stephen, and Matt. And then we're going to jump into the panel discussion and give our speakers a chance to introduce themselves, their organizations as well. And I'll ask some facilitation questions. It'll be a lively conversation. And at the end, we'll have about 20 minutes or so for any questions that you have for the panelists. And then it'll be we'll wrap up from there, and it'll be a quick hour and a half. So without further ado, Mississauga Business Entrepreneur Center. This is us over here, and I am John Lamb, Entrepreneurship and Innovation Specialist for the City of Mississauga Business Entrepreneur Center. For those of you who have found this session, you might already know a little bit about us over here at MBEC. We are part of the Economic Development Office. We offer some really cool stuff. We are essentially your central source for small business information, resources, and guidance, and also now as you're scaling your innovative companies. So things we offer include business advisory services, digital Main Street program, Starter Company Plus program, the Summer Company program, and also additional training and workshops. You can find the additional training webinars and workshops at our website. The URL is listed below there, so feel free to check us out. You'll notice that our Scale Up series in purple will also be listed there, so if you're interested in finding other sessions like today's, then you will find them on the website, and feel free to register for them. And we are here to help. So in addition to myself as the Entrepreneurship and Innovation Specialist, we also have Susan Lovelace, who is the Small Business Consultant, and Laura Dunkley, who is the Digital Marketing Consultant. So feel free to reach out to any of us. Feel free to reach out to us in general if you have any general inquiries at all. We're here to support you in your journey to start and grow your business. So again, small business support and success, you can reach out to our email, our phone, and visit us on our website there, and also via social media. That is our handle at Mississauga EDO. Now, a couple quick words about the Scale Up series. You are at the inaugural session for this wonderful Scale Up series. It's meant to help innovative companies to continue to grow. So whether you have made a little bit of revenue, or you are patent pending, or you have patents already, or you've already secured a bit of pre-seed or seed funding, that's the stage that we are looking to support you with through this Scale Up series. Programs like the Starter Company program, the Summer Company Plus, Starter Company Plus and the Summer Company program, and our other business advisory services are here to help you if you are at an earlier stage. So with this Scale Up series, we have learning sessions, we have mentorship, we have a pitching opportunity that is meant to support your growth and to speak to some of the challenges that you might be encountering, such as the following. So today we're talking about founder issues and legalities. Next week, we'll be exploring founder to CEO leadership evolution, finance options, advisory boards, repeatable marketing and sales processes, going global, scaling your product, and then an investment deep dive to end off our 2021. In January, we will have a Meet a Mentor, a check-in and pitch prep, and a pitch session. These are going to be invite only for those who have gone through all the sessions, who are at the stage of scaling up, and who are within the Industry 4.0 or Industry 4.0 practice realm, or are interested in adopting Industry 4.0 practices. All right, so if you're in Mississauga or want to locate Mississauga and you want to go through all these sessions in the Scale Up series, then a Meet a Mentor, check-in and pitch prep, and pitching session in the new year will be available to you. Please feel free to reach out to me to ask any questions. So about our panelists for today, you can see them on screen already. We have Brenda, we have Matt, and we have Steven. So who are these panelists? So super exciting to introduce you to them. Brenda Hogan, first, is the Chief Investment Officer at Ontario Capital Growth Corporation, and she has over 15 years experience in strategy and execution in venture capital at the co-investment, fund of funds, and fund level investing. Brenda has held senior roles in corporate development, finance, and strategic investing with Bell Canada, Ernst & Young, and the Business Development Bank of Canada, and a software startup as well. She is on the board of Canadian Venture Capital Association and is co-chair of the membership committee, serves with the Institutional Limited Partners Association as a member of the content committee, was co-chair of Canadian Women in Private Equity, and served 3 terms on the board of Women in Capital Markets, latterly serving as chair of the governance committee. She also served on the board of governors at Dalhousie University and chairs the Finance, Audit, Investment, and Risk Committee. Brenda holds an MBA in Finance, has completed the Institute of Corporate Directors SME Board Effectiveness Program, and has received leadership training from the Ivy School of Business. So welcome, Brenda. Everybody give a big round of applause. And then we have Matt Kindry. Matthew Kindry is the head of business law practice group at Palavallo LLP. Matt joined the firm as a partner in 2018 after several years as a partner at one of the world's largest international law firms. Matt has been recognized by Lexpert magazine as a Lexpert Rising Star, leading lawyer under 40. He is certified by the Law Society of Upper Canada as a specialist in corporate and commercial law, and by the Chartered Professional Accountants of Canada as a specialist in corporate finance. Matt has extensive expertise in the areas of mergers and acquisitions, private equity, banking and finance, and corporate reorganizations and restructurings. His practice also includes counseling startup enterprises or general business, corporate finance, and regulatory matters. Matt serves on the board of directors for several for-profit and not-for-profit corporations, and previously served on the executive committee on the Ontario Bar Association, the business law section. He has chaired and presented at over 50 seminars and conferences on topics pertaining to corporate and finance related matters, including structural elements of M&A transactions, MBA in a Day of Transactional Lawyers, Secured Transaction Essentials for Business Lawyers, and Professionalism Issues for Business Lawyers. And you can add Founder Issues and Legalities to that list, Matt, after today. He has written several articles on banking and finance and Canadian corporate law matters. A graduate of the University of Western Ontario, Matt is a recipient of the Law Society of Ontario Prize for Academic Excellence and the Greta J. Grant Prize for Outstanding Community Legal Service. So big round of applause for Matthew.
Thanks, John.
And last but not least, we have Stephen Benny. Stephen Benny is managing partner with Bearskin and Parr LLP and chair of the executive committee. He is the head of Mississauga office and leads the medical devices practice group. Stephen works with clients to assess IP needs and has helped to secure patents for a diverse array of clients, including startups, small to medium-sized enterprises, major multinational companies, and university researchers. Stephen has been proven valuable to his clients in securing their patent rights in diverse technologies, including automotive, medical devices, and imaging systems, electronic devices, communication systems, video and signal processing systems, mass spectrometry, solar power devices and systems, fuel cell technology, internet systems, business methods, and clean tech devices and systems as well. Quite a vast list, which is amazing. He advises on IP management and strategic planning and has prepared many patentability opinions as well as infringement and validity opinions. In addition to his extensive patent work, Stephen has experience in preparing and prosecuting industrial design applications. In 2016, Stephen was elected the president of the Intellectual Property Institute of Canada at its 90th annual meeting. Stephen has contributed extensively to patent education in Canada. He has been lecturing and tutoring for the annual IPIC McGill University patent course for several years and is a past director of that course. So welcome, Stephen. Welcome all of our panelists. As you can all see, we have a diverse range of experience, lots of experience. So we are really looking forward to the conversation that we're having today. So without further ado, I'm going to hand it over to our panelists to introduce themselves, introduce their organizations, and also offer a couple words in terms of their viewpoints on today's topic, founder issues and legalities. Why do you think it's important for us to be discussing this today? Let's kick it off with Brenda.
Thanks, John. A pleasure to be here. I think it's a great topic. In terms of the background, I think you covered it well off in the bio. When I think about, legal issues, as you mentioned, I've been involved in transactions as a direct investor through a fund of funds, directly into venture capital. And so, I've seen both sides, of it in terms of when you're negotiating a deal. And I've also seen a few years later when you need to sort of get out of a deal or monetize or exit or somehow. And I think, for founders, oftentimes when you're starting a business, you're looking to cut costs and you're looking to move quickly, which, is important. I was with a startup myself, so I know the value of that. However, I have seen many situations over the years where, you get to a critical inflection point and then you find out that your legal documents, shareholders agreements and what have you, perhaps they're not of the quality they need to be, and it can actually scuttle a deal and make things very difficult for the entrepreneur. So I kind of think about sort of the legal framework as part of sort of the foundation of a house on which you build, and so you want that to be pretty serious. So I'm looking forward to the panel discussion this morning, and I'm certainly glad to give some real life examples as we move through.
Amazing. Thank you, Brenda. And that critical inflection point is so important. It's, possibly in that scaling phase where that critical inflection point exists, where founders, they might have scraped by with whatever they've gotten done in terms of legal agreements. But as they grow, that critical inflection point is where they need to do a bit of reflection and kind of redo some of the things that they've patched together. So amazing. Thank you for adding your thoughts, and thank you for being here today. I'll hand it off to next on my screen. Stephen, over to you, about you, your organization, and why this topic is important.
Thanks, John. Again, I think you did a pretty good job with the bio, so I'm not going to say too much, other than when I was listening to the practice areas, it was kind of almost like a snapshot of what was hot over various periods of time. I guess we could add to that nowadays as AI and blockchain and things is becoming the more big topics of the day. So it's kind of interesting. In any event, the firm I'm with is Bearskin and Power. We're known as an intellectual property boutique. So that's basically all we do, intellectual property. So we have over 70 plus lawyers, patent agents, trademark agents in the firm with specialties, especially in the patent side, with engineering and science backgrounds of all types of top subjects, from life sciences, genetics, organic chemistry, pharmaceuticals. My background is physics. We have computer science people. So basically, whatever the technology is, we can generally assemble a team to handle that. We have offices in Mississauga, Toronto is the main office. We have Waterloo, and of course, the Montreal office as well, which is great when we get into trademarks and the French language issues. So my colleagues are able to help people when they move into that market and how to stick handle those particular issues. And so basically, when it comes to time to protect ideas, and when it comes to litigation, that's basically IP. That's all we do. In terms of why this is really important, I mean, if the governments have been very keen on promoting IP in Canada and innovation in Canada, and particularly keeping innovation in Canada. I know that's been a focus. And in all my years of being in this field, one thing I do notice is a lot of companies, when they come to us and they want to get a patent or they want to protect something, they don't actually know why. They just know that someone told them maybe you should protect this. And I think it's very important that actually companies come to realizing that, why are we doing this? What's our strategy? How is this going to help us get where we want to go? And I think people need to engage on that discussion really early on and adjust as they scale up. And I think that's something in Canada, there's a very low, a very low knowledge of IP and what it's for. And I think topics like this, panel discussions like this, will go a long way to help, I think, companies understand and appreciate how IP should fit within their strategies and get them to where they need to go.
Amazing. Thank you so much, Stephen. And yeah, what you said about, keeping innovation in Canada and people don't know why they protect IP, that's part of that scaling process, right? As a startup, you might hear from people, you need to protect IP, you need to do this, you need to patent. But the strategy, that's where it gets really interesting as the company is growing, because there are, some things that you can do, and it plays a part in how your company will continue to grow and how big it will grow and in which ways the company will grow. So, yeah.
Not a checkbox strategy. Yeah.
Yeah. All right. So, Matt, over to you about your organization, and why you think this topic is important.
Thanks very much, John. Good morning, everyone out there. I think I'd like to, I received a great introduction from John at the outset, so I'm not going to repeat what he said there. But I would like to start by thanking our hosts this morning for all their hard work in organizing this session. I know these sessions require a great deal of organization, and our hosts have done a wonderful job in bringing this session together. John mentioned a little bit about me at the top. For those of you who are not familiar with my firm, the firm I'm with is a firm called Pellet Vallow. We're the largest firm in the Peel region. We're a full service firm. Our head office is in Mississauga, but we also have offices in Toronto and Vaughan. In addition to the business law practice group, which I lead, the firm also has practice groups dedicated to various different practice areas, including litigation, employment, and real estate. So focusing on being able to assist our clients in all aspects of their legal needs. This is a pretty broad topic today, and as I'm certain many of you here will appreciate, the issues facing founders and early stage businesses are vast and quite varied. There's issues that arise throughout the day. You have to deal with IT in between onboarding new employees and managing your supply chain. So I guess in the opening remarks this morning, what I'd like to focus on is a few legal pitfalls that I see startups and emerging businesses fall into on a regular basis. And I'll just highlight two. I think the first one, which I see probably most frequently, is the failure of businesses with multiple founders, with multiple shareholders, to have shareholder agreements in place. And for those of you who aren't familiar with shareholders agreements, they're private agreements that supplement the applicable corporate statute and other constituting documents of a corporation. While a corporation with one shareholder doesn't typically need a shareholders agreement, where there are two or more shareholders, where there are two or more founders, a shareholders agreement is highly recommended. I often tell folks who I'm meeting with for the first time that it's easy to think when starting out that the founders and other shareholders will always agree or be able to resolve any disagreements because they're close friends or they're family members. But there are literally thousands of proceedings brought every year in Canada that arise out of disputes among shareholders. And so it is important to try to set out from the outset what everybody's roles and responsibilities are and what will occur in certain circumstances. The second pitfall that I would just highlight off the top is, and we see this quite frequently, and that's the failure of new businesses to have employment agreements in place when they hire employees. And the principal issue with that is when you hire an employee, if you hire them on a handshake, that becomes your employment agreement. It's very difficult to put an employment agreement in place after the fact. And so from the employer's perspective, from the business's perspective, the employment agreement can reduce termination and severance costs in the future, but more importantly, it ensures that the employee's responsibilities and duties are clearly set out, and also ensures that the corporation or the business owns its intellectual property, and that its customers and other employees are not solicited by an exiting employee upon termination. And so those are issues that we see arise quite frequently, and quite frequently when these issues come to a head when somebody's looking to raise capital. An investor comes in and says, okay, show me your employment agreements, show me that you own all your IP. And the founder looks at them and says, well, we don't have employment agreements. And then they're forced to put them in place. And as I said, you can put them in place after the fact, but as with most things, it's easier and less expensive to put them in place at the outset. So I'll leave it there for the time being, and I'm always happy to sort of dive into those topics a little bit further. But those are just a couple of pitfalls that I see, at least from the legal standpoint, of that founders and emerging businesses sometimes fall into.
John, if I could just pick up on a couple of the points that were just made, sort of speaking from the investor side of the table. I think back to a couple of situations that I observed, sort of real life case studies where a company was undertaking a round of financing and everything was going really well, and the due diligence was going well. And then what happened is there became some lack of clarity as to who actually owned the IP, because it had spun out of an institution. And a gentleman came forward and alleged that he had been part of that. And so obviously as an investor, when we make investments, particularly into companies, I'm speaking now, we part of the driver may be some proprietary, IP that we see as a differentiator in the marketplace. And so it's really important for us to understand, who owns it and who has claim to it. It's a bit like, if you're buying a condo or a house, you don't want to sort of be having the moving van unpack and find out that you don't actually have the rightful ownership, of the home. And so that's an important piece to clarify early on. And then picking up on a second point that was just made around sort of, the cap table and understanding, in the shareholders agreement who owns it and what their rights are. I saw another situation where a company was undergoing an M&A transaction, and what had happened is it turns out that one of the shareholders had passed away, and the deal was held up for a considerable amount of time because the company had to go and find the widow of that owner in order to be able to move the transaction forward. So those are some things that, in hindsight, probably could have been, dealt with much earlier on in the process.
Yeah, definitely. Thanks, Brenda, for jumping on that. And that's wonderful insight because, as Matt, you mentioned, it's a broad topic, also with broad impact. So whatever we can focus on in terms of those inflection points or those critical points like shareholder agreements and employment agreements, I think that would really help the audience that we have here today. So before we kind of jumpstart, we have a wonderful set of attendees here. We've got 24, and although you can't really see each other, please feel free to jump on the chat to ask the questions that you have. We have time afterwards, and I'll be reading out those questions to our panelists, and they will answer them. First, we'll kick it off with a bit of a panel discussion. And for those of you who are watching this recording, please feel free to reach out to me for any additional questions that you might have afterwards as well, if it's not already answered in this session. So thank you for the introductions. And before we kind of jump on this idea of founder issues and what could go wrong, things like your partner passing away and you have to figure out the legalities afterwards. what are the things that could go right? You know, like how have you seen founding teams really succeed, and how have they done that? You know, in not just the context of the legal agreements that they put in place, but also perhaps some of the intangibles as well. So maybe we'll kick it off from the IP standpoint, Stephen. How have you seen founding teams really succeed?
That's a good question. I mean, and to be truthful, to kind of evaluate that question, it's good to look at how you see teams that don't succeed a little bit. And I find when it comes to particularly startups, I mean, they're really focused on the technology. And the founders are often the ones who have developed the technology. And that's their expertise. And that's what they really know, and they love that area. And when you move from developing a technology now to a working prototype or a software solution, depending on what it is, and you're now moving out into the marketplace, sometimes if your team is really you and maybe a few other developers, how are you going to move forward? Who's going to be presenting the idea? Are you good at that? And so asking yourself these questions is, what's my strengths? What are my weaknesses? And who am I going to put on my team to help fill in my weaknesses so I can make this a full company, a good offering? And I think that's a good analysis I think founders have to kind of go through and fill in the gaps and figure out how am I going to move this forward. This kind of moves into the next question, which we'll get to. But I mean, I think I think that's a really good thing. It's like, what do I need to do to move this forward? And quite often the founders, I've seen a few pitches, and you need someone really there to help make that. And what about sales? Do you have the right people in place to make the sales? Because at some point, it's nice to have the idea, it's nice to have the investments if you can get that, but what about sales? How are you going to get to the sales? And so really looking at your team and saying, is this the right team do I have, and what can I do to make it the best team possible? I think goes a long way on that. And those that do have that great team, I find are the ones that really succeed.
Amazing. So what you mentioned, Matt, about shareholder agreements and employment contracts. So you see the makeup of the team. You see the mix, from a startup standpoint, and as they grow as well, they're going to be coming to you for employment contracts. So Matt, the question for you, like, given what Stephen said, what mix have you seen that has been really successful? Like, do you see that a founder with that technology development background, and they have that pairing with a business background, that has really succeeded? Or is it the other way around where, they continue to grow themselves from a technical standpoint, and also grow themselves as CEOs? What's that mix? Have you seen a successful recipe?
Well, that's a good question, and I think I'd answer that by saying there is no magic formula. There isn't, take two-part tech person, one part CEO, and arrive at the perfect mix. Every business, every industry is going to have, leaders who have different qualities. And, to build upon what Stephen said, I think, the most successful of those leaders or leadership teams, if it's a group of people, is recognizing their own strengths and weaknesses and their own limitations, and finding people who complement them. And so, again, the number of times I have seen founders who are they're geniuses in whatever technology they've created, but can't sell their idea. That's a really common occurrence, and they do really well when they partner up with somebody who is able to bridge that gap between the founder and the customers. And to sort of build further on what Stephen was talking about, I really think that the most successful founders or founder teams that I've seen, they don't just focus on their product side or their development side, but they also focus on the business side. And that can be a tough, that can be difficult for them to do, because that might not be where their area of expertise lies. But it's important. It's important to set out a roadmap, to assign responsibilities, to think about how you're going to approach and ultimately reach your goals. And so the most successful teams that I've seen sit down and prepare a business plan. And they may do it with the assistance from outside advisors, be it lawyers or mentors, but they have a strong business plan that shows them where they want to get to. So we want to achieve, we want to achieve 1,000, sales by X date. Okay, what do we need to do to get to that point? And this isn't so much a legal standpoint. It's just, what I've seen successful founders sort of do over and over again. And I think what's important to note is that your business plan isn't something that's set in stone. You may have a roadmap of where you want to be, and you may get to step 3 and find out that this isn't going to work. And so you have to pivot and change, and that's fine. But having a roadmap with deadlines and goals and dates, allows you to work towards something and ensures that you don't get bogged down in the minutia of development, because it's easy for that to consume your entire world and not concentrate on the other aspects of the business, which really need focus. The number of businesses which I've seen fail because not because they don't have a great product, they do have a great product, but because they're not able to vocalize why their product's great, or they're not able to keep employees to help them develop their product, or they're not able to market their product. There's a large number of companies that fail just because they don't have the plan in place, not because they don't have the great idea. John, you're on mute.
Sorry, it took a second there. There's a bit of lag with WebEx, I guess. So that's an excellent point. And I think back to the companies that I've worked with, I've mentored, and I've coached. There are some who shoot themselves in the foot because perhaps the founder has that technical background, but they're kind of unable to have that conversation with themselves to really reflect. Am I the right person to take this forward, or do I need to take on a more specific role and bring somebody else onto the team? And next week we're talking about founder to CEO leadership evolution. So we're going to dive a little bit more into that. Brenda, for you, you've probably been in some of these tough conversations with the founding teams about really having that reflection of where the strengths and weaknesses are, who you need to bring on board, and how the team needs to evolve and change, right? What are some tips that you have for some of these founders who might be at this point of starting to recognize that they need to have these types of conversations?
I mean, John, one thing I would say is I haven't met an investor yet who relishes having to change out a CEO or anyone in the C-suite for that matter, frankly. Because really, when you invest, part of what you're investing in is the team. So, if you invest and then you realize that there's issues, that's a huge disappointment, to put it mildly, right, on the part of the investor. Having said that, changing out the CEO or anyone in the C-suite, is akin and you may have heard me use this expression before, but is akin to, changing out your electricity at home when all your lights in the house are going, right? Like, this is not an ideal situation. So I think it's about, making it work the best you can. The one thing I would say, and this is just back on legal agreements for a minute, I've seen some teams say, I'll ask them, back when we were doing a lot of direct investing, I'd ask them a question, well, how are you going to deal with X in the future? How are you going to deal with Y in the future? Have you talked to your co-founders about this? Have you talked to the shareholders about this? And oftentimes sometimes I get the answer, well, we can't really agree on it. Well, for me, that's a red flag, because if they say they can't agree on it now, how are you going to agree anymore? Let's say when you're caught up in an M&A and the economics may not be equitable to everybody, and all of a sudden then you're having to have these conversations. And if I can just sort of step and just speak about legal counsel for a minute, because I don't think we've turned our attention to that yet on the panel, but when I think about choosing legal counsel, my own experience and what I've seen from the portfolio companies and other investors, ideally you want legal counsel who's experienced in the issues that you're dealing with, right? Because just like, for a doctor, if you had, a foot issue, you wouldn't go see an internal medicine specialist, right? You go see a podiatrist or some other specialist. And I think it's like that with law too. And in my experience, the lawyers and the firms I've most enjoyed dealing with are the ones who just have so many transactions under their belt. Almost anything I can throw at them, they've seen it before. They've seen it go well, they've seen it go poorly. I think that would be one point. The other point in choosing legal counsel, and I speak from experience because years ago I was working with two firms, and one firm was extremely adversarial. And when we needed someone to be the bad guy, they were like the perfect lawyer to do that. That's the exact role they played. Other times we'd have a transaction where I needed someone who could be almost like a concierge at a hotel when everybody wants the best room, and sort of a very different demeanor. So I think it's about thinking about, what kind of legal counsel are you comfortable with? Because when you think about it, if you're the CEO or the CFO or whomever at a tech company, oftentimes the legal counsel, the discussions are between counsel to counsel, right? And so your counsel is actually representing you. So you want to make sure that whoever's representing you is representing you in a way and in a manner that you're comfortable with. And so, someone running a tech company might say, well, gee, how am I supposed to find a lawyer like that? Well, that's where referrals come in handy. So, oftentimes, if you're with a tech company, you've had to deal with, I'll call it opposing counsel, but the counsel for the other party. So you can kind of see, what was your experience with them. You can talk to other CEOs and CFOs. And if you're a CEO, I wouldn't necessarily just stick with talking to the C-suite, because in my experience, what often happens is the CFO may retain the lawyer, but then it may be a director or a more junior person who's actually dealing day to day. So I would get the impression of those people. And then I'd also actually get the impression of other investors, right? And other shareholders, because again, they've been on the other side of it, and they can sort of see how that particular partner or lawyer has operated. And so those are some of the things that I think would be quite important, because oftentimes I find in negotiations, you can usually find a way to deal with stuff, but it's the human dynamic that trips people up. And so having counsel that you're super comfortable with for all the reasons I just explained puts you in a good place. And back to your original question, John, when you are having to have these issues with management, either if someone on the team needs to be exited or someone needs to be brought on, having counsel who can help advise you and paper it properly is pretty important. Because you do find that you have seen cases where they got into a fair bit of litigation over the terms of the employment. Were they an employee or not? Did they own shares or not? Had the vesting period been met? So it's much cleaner, because I think when you're running a business, you've got so many issues. You've got competition to deal with, and in some cases you've got regulatory advice. So the things that are kind of within your wheelhouse, within your company, the best that you can sort of contain that in an orderly manner just frees you up to deal with all the things that you can't control.
Yeah, that's so important. Whatever you can kind of clear off your plate and focus on what you can control, then that just helps your strategy, helps you to execute and to grow and to get clarity as well. Because if you let the things that you can't control in and cloud your judgment, cloud the way that you see things, you're not going to be able to control the things that you actually can, right? So it's important to have that focus. Now, I want to go back to your point about finding the right doctor for your condition. Essentially, it was the analogy, right?
Yeah.
So, having started businesses while I was a student, I can admit I've been guilty of finding templates and just patching things together, to get that out the door without consulting with a lawyer, because I didn't know better, right? So from a legal perspective and also from an investment perspective, like, are those really glaring? Like, can you point out, yes, this was just a Google template, they patched it together, and how do you suggest teams to navigate these issues? Because part of the problem could be they don't know which doctor to go to, right? Like, if we have, if your toe hurts, you can go to your general practitioner and then they can, refer you. How there's, like, is there a general practitioner? Do you just suggest reaching out to anybody and then they can refer you. How do you navigate that, as a founding team who might not have information about which legal services pertain to their particular situation, and without having a context of knowing what their situation actually is, what that problem actually is, and who can solve it for them?
Well, I mean, John, I can give a couple of suggestions from the business perspective. I know my fellow panelists will probably have some good ideas too. The two things I would say is, one, it sort of goes back to referrals. So you can go out to your network and say, look, these are the issues we're dealing with. You don't have to have the solutions, and you don't even need to maybe fine tune the problem. You can just say it's an HR issue, it's a person issue, or it's an IP issue, just to kind of get the conversation started. And then I know that a lot of the accelerators and incubators and so on and so forth throughout Ontario, they often have what they call, I forget the formal name, but basically they have a lawyer that shows up a day or two a week and provides oftentimes, pro bono, opportunities to discuss a situation. And that may be a place where some of these more fledgling companies could start.
Yeah, and John, I'll pick up on one of your earlier questions there about, templates and where you get them from. There are some really good legal resources out there, but moving into anything that is a sort of a more complicated agreement, there is a benefit to having legal counsel review it or prepare it for you. And often, if you have a relationship with legal counsel, they'll be able to assist you in minimizing, your costs. And so, I take myself as an example. We have a standard form NDA, which I'm more than happy to share with clients and prospective clients. It's a very standard type document, and it doesn't require much customization. But there is a short conversation that you need to have with, or I think that you benefit from having with a lawyer, to understand what it means, what it covers, what it doesn't cover, because it's not a one-size-fits-all solution. And as you move into more complicated agreements, pulling something off the internet is it can be detrimental. It can be do more harm than good. And examples of things that I've seen people take employment agreements that were used for a similar business but in Texas and tried to use them in Ontario. And Ontario and Texas have dramatically different employment laws. And so what you've put in front of the employee is of zero value to you or the business. And you see that happen with any number of agreements where people try to take an agreement or something that they found off the internet and document and change it for their own use, and that can be dangerous. And you might be giving away more than you want, or you might be might not be protecting yourself the way you want to. And I saw in the chat a question that came up about that legal fees can be expensive, and I would agree they can be. But I think that if you're dealing with a good lawyer and a good law firm, that you can have those conversations with your legal counsel at the outset. I have a budget of this, or I'm a startup. I don't have much available cash. And listen, good lawyers will work with you. They will understand. Okay, this agreement needs a quick, high-level review. All law firms have different levels, so there are some matters which I take a very active role in, while others are delegated to a more junior lawyer because it's an appropriate matter for them to deal with. But at the end of the day, there is a benefit to having legal counsel assist you with these. And oftentimes what I see is that the cost of fixing a problem is much more expensive than the cost of having the problem done correctly. And to Brenda's point, there are legal clinics that are run. We run one for the RIC Center where we talk about a number of these things at a high level, and then we have office hours where we provide guidance to early stage businesses on how to deal with certain matters. We have startup checklists and forms of agreements that we tend to share with new clients who need those assistance. And so there are resources out there that you can rely upon. But again, pulling something off the internet, I caution you that it can be dangerous.
And just to follow up on the patent space, which is particularly where I work in, patents are really a legal agreement between, the company or the individual, depending on how it's set up, and the government that you apply for. And there's usually two components to it. One is a teaching component, and the other then is your legal contract with the government as to what you can carve out as your exclusive right. And I think, once you understand that a patent is really a legal agreement from that perspective, understanding that it's got to be drafted well to carve out what is yours becomes pretty critical. And you can go online, you can download patent documents from public databases all around the world. And you can see they do have that common form where you have a disclosure and then a claims section, which is a legal agreement section. But, how do you write an application? I mean, that varies from jurisdiction to jurisdiction. In some jurisdictions, they have what we call a problem solution approach. Others utilize what we call the witness approach, where you just answer the bare minimum questions, as opposed to showing a problem and a solution and overstating certain things. So it is something I think you do need to engage with a professional fairly early on in the process. You do have to have a strategy to know what it is that you're applying for, where you're applying for it. Is it a multiple jurisdiction type document? And just an understanding that this is really a legal agreement between you and the governments that you're applying for. I think a lot of people don't appreciate that, particularly when it comes to patent documents.
I mean, if I could jump in, and just comment on legal agreements in general, whether, whatever kind of agreement it may be, is that, I think back to when I was with Bell and we were building out the venture capital portfolio, and we were drafting shareholders agreements with our counsel and what have you. And then a few years later, the strategy changed and the direction was we had to divest of everything we had invested in a few years back. And so anytime I look at an agreement now, I think of, okay, if things don't go as planned and perhaps we need to get out, what happens? I look at clauses and I think, okay, well, this is how I interpret it. How might the other party interpret it, right? Because oftentimes when you're writing the agreement, you think, well, everyone understands that it means X. But if you're ever on the other side having to go back to that agreement 5 years later and the parties may have changed and people move on, how might someone with fresh eyes interpret it? And they may interpret it to a way that's not to the CEO's advantage. So that would be one point I would make. And I guess the other point I would make, and this goes back, I know it was Matt or Stephen who had said, but when you go into these companies, you go in oftentimes with co-founders from university or people that from your workplace or down the street, and everything is fine. And so one of the things I look at is I think, what is the worst that someone could do to me, and that kind of sort of sets the parameters. And so if you understand what's the best case scenario, and you understand what is the worst case scenario, then you can craft something that will actually, I think I would argue, actually would preserve a relationship. Because when you get into some sort of debate or discussion, the nicest thing you can do to preserve a relationship is go back to the agreement and reference that.
Yeah, well, that's a good point. In the patent space, there's a couple of things you have to consider. And going back to what Matt mentioned earlier, who's the owner of the patent? And then you also have another concept of who are the inventors of the technology that's in the patent. And in absence of any agreements, like employment agreements or other agreements, the inventors can be owners. And if you don't identify all the inventors in the document, you leave yourself exposed to down the road, you could have an issued patent and you're trying to enforce it. And someone says, well, wait a sec, here's a person who should have been an inventor. They weren't named. There's no obligation for them to assign to the company because there's no agreements in place. And now there's no loyalty to the company anymore. We'll have them added as an inventor to the case, and they can assign the rights to me. And all of a sudden, boom, any infringement questions off the table because I'm now a co-owner of the patent. And so these are things that can happen, and it's worst case scenarios. And that goes to your point, like making sure that you have all these things lined up and dealt with very early on to avoid any of those kind of issues, which are way more expensive down the road to handle.
Mm-hmm. So it's very preventative, right? You're trying to prevent these worst case scenarios from happening, which is a difficult task, for founding teams, a difficult exercise to entertain, to think about those worst case scenarios. So can you provide examples or stories of fixing the problem, and how fixing the problem has actually costed the company more than if they had just prevented it? Because I'm seeing some questions in the chat about the fees and whatnot. How has how or do you have examples of fixing a problem costing more? Do you have stories about founding teams who have paid a lot more to fix the problem? And also, does that change depending on the stage of the company that you're at, and also perhaps the industry that you're in as well? Are there examples of fixing a problem costing more? And do you see different industries or different stages of the company costing more than other industries or stages, or perhaps less as well?
I can start off on this one. And so, I mean, what I would say generally is that the longer an issue goes undiscovered, the more expensive it is to correct. It's pretty easy, you form a business with your college roommate, or you form a business with your good friend, and 6 months in, you decide to put a shareholders agreement in place. The incremental cost is small to if you would have put it in place at the very outset. It's, there's almost no difference. You wait 6 years down the line, suddenly there's a real divergence or there can be a real divergence in everybody's life goals and in situations. And the story that I always like to tell people is that you can have two people who look at the same scenario and want to go in different directions, and neither of them is being unreasonable. And so you can have a scenario where you start a business, you grow a business with your friend or your business partner, and somebody comes to you both 5 years down the line and says, I want to buy your business for $2 million. And you say, fantastic, all right, great, I'm now a millionaire, I want to sell my business, I get $1 million out of this. And your business partner goes, I really think the business is worth more than that, or this is my entire life, I don't want to sell the business. And so neither of you are being unreasonable, neither of you are being malicious, you just have different goals. And so part of the benefit of a business plan, part of the benefit of a shareholders agreement is setting out, what your goals are, making sure that everybody's aligned. And also with a shareholders agreement is setting out, okay, when that situation arises, how are we going to deal with it? And there was a question in the chat about, what happens if you don't have a shareholders agreement? What's the default? And the default is the corporate statute, but the reason that shareholders agreements are put in place is that the corporate statute doesn't deal with how to address that, two shareholders owning 50-50, one wants to sell, one doesn't want to sell. The corporate statute doesn't address that. That is something that the shareholders have to address separately. And we have a dispute in our office right now, which I'm consulting on, but it's in our litigation group, unfortunately. And it's two brothers. Two brothers started a business together. The business is worth in the tens of millions of dollars. So like it's and it's been around for decades, 30, 40 years. And there's a big dispute over one brother wants his son to take over the business, the other brother wants to sell the business, and they can't resolve their differences. And it has become litigious. The two brothers suing each other over this scenario, and they've each spent hundreds of thousands of dollars in legal fees. So you have two brothers with a business that they built up together that's worth, as I said, I think it's almost worth $100 million. So by every metric, they've been successful, but they're at each other's throats, and they're not talking to each other, and they're spending money on legal fees, where if they would have had a shareholders agreement in place from the outset, a shareholders agreement probably would have addressed how this scenario would have been resolved. And it's not that they would have been necessarily happy with the result, but to Brenda's point, they could have said, no, remember the shareholders agreement we signed 20 years ago? It says that in this scenario, this is how we deal with the problem. And instead of spending money on, litigating over it, it's set out in contracts. So the situation gets resolved faster, less in a less expensive manner, much less expensive manner. And it has the ability to save the underlying relationship. And, I can tell you that in the present case, that dispute between the shareholders, between the founders, is significantly harming the business, and they're going to end up going to court. Like in the new year, they're not able to resolve their differences. They've tried. They're going to end up going to court, and they're going to spend more money. And I can guarantee you that the judge who decides on the case, neither of them are going to like that result. So that would be sort of a long answer to your question, John.
And to add to that, for those who are listening live or listening to the recording who think that because you're dealing in a family situation, be it a brother, a sister, a cousin, an uncle, that you don't need anything papered because you have the relationship, let me relieve you of that confidence, because some of the most acrimonious discussions I have seen have been amongst family members. And oftentimes you will have a family member who will say, and I've heard this so many times, well, we don't want to sort of paper anything because we don't want to damage the relationship. And I'm thinking, if someone's asking you to not paper something or to agree to something that's not fair to you, then I think you have to ask yourself is, how worried are they about the relationship if they're prepared to put you in that position?
And I think on the IP side, the most common issue we see is the ownership and inventorship disputes. And if it's not properly papered at the beginning with employment agreements, shareholder agreements, and all these kind of things, it's very hard to prove who did what down the road. And one thing we've seen is companies maybe don't do IP, then some group splits off, they form a new company, and then they start filing the IP that the other company should have been doing, and they come to us and say, the other company comes to us and says, well, wait a sec, can we now protect it? And it's like, well, what did you do? And you said that's yours, but how can we show that? And trying to do these things after the fact is definitely way more expensive than trying to keep it all wrapped up at the very beginning. Ownership and inventorship disputes, I would say, are the two things that can often destroy a startup company in the early stages.
Yeah, and I would agree with Stephen on that 100%, especially when it comes to raising capital. You never want to be, an investor who's investing in a startup company and then finding out that there's ownership issues regarding IP, because ultimately you're investing in the company, and usually the IP is their single largest asset. And so, that's a red flag, and it's usually fatal. So if there's a dispute over IP, the investor just says, thanks very much, but I'm not getting in the middle of this, and I'm not going to sink my million, my $5 million, my $10 million into this when I don't know what I'm buying. So I'd echo Stephen's sort of comments on that.
So it seems like fixing a problem, those increased costs come in the form of the time and money that you might have to spend in court for a dispute. It might come in the form of relationships, really good relationships that you have that will get derailed, and you no longer have those relationships. So there's an intangible factor. And then also opportunity costs in terms of competition and competitors, using the IP and claiming it for them, and also opportunity costs in terms of investment dollars as well. So there are many areas where things will get a lot more costly than the money that you spend on getting an agreement together through a lawyer, through legal counsel. So thank you for highlighting those examples. And yeah, Brenda, did you have something?
I was going to say, I think you're right, John. I was just sort of thinking back as I was listening to the discussion. I mentioned, or you mentioned in the bio, that I'd spent time in M&A too when I was with Bell, and and now as an investor, and I think back to a concept people call deal fatigue, right? So whether you're raising a financing round, be it from angels or a venture capital fund, or you're selling your company at some point, whoever's looking to buy your company or whoever's looking to invest in your company, they only have so many hours in a day and only so many on the team to actually do the work. And something that can set in is what I call, I think others call to deal fatigue. So you've got like most people at any one time, they're looking at 3 or 4 or more investment opportunities, 3 or 4 or more acquisition opportunities. Particularly if you're a corporate, you're probably looking at dozens at any one time. And as you're sort of going through and dealing with the founders and doing the due diligence, you kind of can get to a point where every time you look at a certain opportunity, it's just one more issue and one more issue and one more problem. And then you kind of start saying, well, okay, well, there's this other deal over there that's not having all these problems. Let's go spend some time on that. And then you kind of don't make your way back to that other one, right? And so that's something to be really mindful of, because you think of the cost of having that happen to you is it could be catastrophic. So I think I think what we're all sort of hearing and saying this morning is there are things that you can control within what I call your own house. So get those buttoned down, so that when you're dealing with the competition and all those other issues out there, that you're not having to check to see if your own house is on fire. You can actually run forward and deal with the competition.
Yeah, and sorry, go ahead, John.
No, go ahead, Matt.
Oh, I was going to say there's a couple of questions in the chat which I think sort of dovetail nicely with what we're talking about there, and about the costs and how do you frame a shareholders agreement. And I know that we keep coming back to shareholders agreements, but they are an important document. And what I would tell you is that there obviously is a cost to putting a shareholders agreement in place, both in terms of time and money. But if you're dealing with good legal counsel, if you're dealing with good advisors, the shareholders agreement that you have at the early stage is not going to be the same shareholders agreement you have when you do your Series A. Or when you get more advanced. They tend to build upon each other. And so the shareholders agreement that you put in place initially is, I don't want to say it's a simple, straightforward document, but the decisions around it and the negotiation around it are much more straightforward. And they can usually be produced much more quickly and much more efficiently than when you get to a later stage. And so talk to your lawyer, whether it be myself or somebody else, about what that cost is, and oftentimes you'll find that it's maybe less than you expect, and certainly the benefits can far outweigh the cost. And someone was talking about how do we make sure it's equitable. I can probably tell you, based on the situation, so if you're 50-50 shareholders, for example, I can go through with you relatively quickly what's standard and what it looks like, and probably flesh out 75 to 80% of it with you without very, very quickly. And it's that last 20% that's sort of customized and bespoke. But when you see a lot of shareholders agreements, there is a degree of what I would call market practice to them, depending on the scenario. So obviously a 50-50 shareholder relationship is quite a bit different than a 70-30, but a lot of the 70-30 shareholders agreements look a lot the same. There are differences between them that you have to be cognizant of, but there are very similar concepts and business points that get raised in each.
Mm-hmm. Amazing. All right, so we're gonna switch gears now. We only have about 22.5 minutes left in the session, so we're gonna try to do a bit of a lightning round with some of these questions that we have in the chat. So feel free to chime in wherever you each see fit. So first off, with virtual companies being much more prevalent, is it okay to use a home address as the legal address, or should a virtual business address be set up? I think that's probably a question to have with your individual lawyer. So any quick 10-second responses to that?
Yes, it's okay to use a home address. Just know that it's going to be public.
Gotcha. All right. And next question, how do you put together an equitable founders agreement that doesn't favor the more liquid founders?
So that's a good question. So and Brenda, Stephen, jump in here with your thoughts as well. But again, that's the when I was talking about sort of that, that 20% that gets gets customized. Those are the types of issues you want to discuss with your legal counsel in advance. The big provisions that favor liquid founders or founders with money are provisions like shotgun clauses. So they may not be appropriate where you have somebody who is the money versus somebody who is, so you often see in relationships, somebody's brought the money, somebody's brought the expertise. And so you want to make sure that the shareholders agreements are equal in those respects, but it's no one provision. It is, it's something that's throughout the document and something that needs to be taken into consideration.
And probably worth a conversation between the founding team as well to kind of figure out what might be equitable for each other.
That's right. Yeah, because I think, being equitable doesn't necessarily mean everyone gets the same thing, but everyone's position should be recognized. And again, going back to the family example, because there's so many businesses that are founded by siblings and cousins and what have you, is that oftentimes what you will find is the siblings will all sort of start off with a similar net worth. And as time goes on, because of what's happening with their spouse or whomever, the financial foundation diverges. And when that starts to happen, how people look at the business can change.
Yeah, dynamics shift and change based on external factors that might not be controllable for the founding team specifically. So next question then, from your experience and in the context of fundraising transactions, what have been the common mistakes you have seen early stage founders make?
So I guess, we've talked a lot about shareholders agreements. One thing that we haven't touched upon is when to raise money. And I think that, something that I've seen quite frequently is that people are in a rush to raise money because they think it's a benchmark that demonstrates a level of success, right? I've raised my Series A. Equity is the most expensive form of investment for the business. And so, there's a time that you should be raising capital. And for most businesses, it's something which is necessary, but don't be in a rush to do it. There's a right time, and to be honest, this isn't so much a legal point. You're not going to talk to your lawyer about whether this is the right time. It's looking back at your business plan, talking to your advisors and your mentors, and figuring out, is now the right time to bring on that investor. Because bringing on an investor is a big step. It changes the dynamic of the business. And so, ultimately, that's an issue I've seen people sort of fall into a number of times, is raising a Series A or raising an initial round too early, just because they think it's the next step, because they want to be able to say, oh, I did this.
John, maybe one thing I could add too, because just as Matt was talking about the various issues, I started to think a little bit about board governance. And, a lot of companies, obviously they'll have boards, and particularly once they get angels and VCs, they usually will somehow get a board seat amongst them. And it's interesting because outside my day job, I sit on a number of different boards, university boards and what have you. And the startup community is about the only place where I see so much conflict by design. So oftentimes you have the CEO on the board, you may have someone else from the C-suite on the board, you have an angel investor on the board, a VC investor, sometimes the bankers on the board, and those people do bring value. But when you think about what a board's there to do, what I would say to any founder is, for example, we talked about HR problems earlier in the call. When you put together your board, it might be kind of handy to have someone at the table who really understands HR super well, right? Because that's someone who can provide that founder some advice and look at issues when they come to the board through the HR lens, just like it's helpful to have someone with a finance background on the board, someone with a legal background, someone with subject matter expertise. So if you're a company that is in the mobile space, you'll have someone there who understands mobile. If you're a company that's selling into, corporate America, have someone there who understands how a multinational actually functions, right? And so I would say board composition is in the other area where some thought ought to be given.
I love that. You're giving a teaser to our advisory board session happening later on in the fall. So
Okay.
yeah, stay tuned. Stay tuned, everybody. There's more about boards coming up, and I hope that piques your interest. So Stephen, from an IP perspective, anything to add?
Yeah, well, the one thing that comes up a lot from an IP perspective is the issue of confidentiality. And particularly in the patent and design space, most countries of the world work on what's known as absolute novelty. And what that means is once you've publicly disclosed a major invention available to the public, then you are prevented from filing a patent application. And so in an early stage company, being aware of that is critical. And in your roadmap or business plan, being aware of the stages of, okay, when do I have to go public with this for perhaps fundraising or for whatever, and do I have my protections in place before that stage? I think it's critical to consider. And we find a lot of companies haven't thought about that. And when they come to us, they've made a disclosure, and that kind of sometimes limits what we can protect. So that's a super critical point, which a lot of companies aren't aware of.
Yeah, so kind of similar to Matt's point about timing, right? Not just the timing of the raise, but also the timing of the other activities as it relates to raising funds.
Yeah.
Awesome. So on to our next question then. How should the founders frame any shareholder agreements to protect themselves and or be advantageous to themselves?
And so I can jump in there. I think we've covered that a little bit. And sorry, I might have jumped ahead of you, John, and looking at some of the questions and trying to answer them during our panel discussion. But again, each shareholders agreement is going to be somewhat unique, and everybody's situation is somewhat unique. And so it's really a frank discussion between yourself and your lawyer as to how that should be set up to be fair to everybody, to provide everybody with protections. And again, much easier to do at the outset than 10 years down the line.
I mean, maybe one way to think about sort of from the investor perspective is I often think, put myself in the shoes of the CEO and think about, okay, what are you worried about? Chances are you're worried about being pushed out of your company when you don't want to go. You're going to be worried about what kind of decisions you have autonomy over. You're going to be worried about financial implications for yourself and for the company. So I kind of think, what's your worry list? And then when you have your discussion with counsel, they're going to bring obviously sort of the standard things that everybody's kind of concerned about. But if you can kind of sort of articulate what you're most worried about, that is a helpful piece to the conversation.
Yeah, and just to build on that point, I mean, when I have a conversation with somebody about a shareholders agreement, we have literally a checklist of things that we go through with them to discuss sort of, here are the areas in which you should be thinking about. Some people are more than happy to get bought out so long as the valuation is at a certain point. Other people have I have a client has a startup, but he's got a lot of family money behind him, and so he's never concerned about not being able to, if push came to shove, and somebody was to issue a shotgun notice or something like that, he has access to the capital, so that's not a concern for him. And so everybody's situation is a little bit different, but we certainly have a list of things that we go through with our clients to say, okay, have you thought about this? Have you thought about this? What's your sort of pain threshold here?
Mm-hmm. And with that pain threshold and the worry list, as you grow, there might be some things that you have to review and be willing to compromise, because if you're saying I'm keeping 100% of the equity, but I also want external investment, that's not going to work, right? So you're going to have to review it. Yeah.
Yeah. So if Brenda's investing $1 million in your company, she's going to want input or outright vetoes over certain transactions. She doesn't want you hiring your cousin who's fresh out of university to a $250,000 salary to be your marketing manager when he's got no experience, right? So she's going to want, and she deserves, to be quite frank, to have some safeguards in place to protect her investment. But at the same time, if she's only purchased a 10% stake in your business, she doesn't maybe get to make all the personnel decisions. And so a shareholders agreement at that level, when you have a significant investor coming in, is going to look a lot different than your shareholders agreement at an earlier stage. And it's going to address a different set of concerns for both parties.
And actually, Matt, that's an interesting point because, when you're having, as a CEO or as a company, having the discussion with a potential investor and you're having trouble to land on terms with your respective legal counsels, some people say, well, once we get past this, everything will be fine. But I mean, if you're fighting even before, you're all around the table, as an investor, that may give a chance for the CEO to sit back and say, is this actually an investor I can work with? Because certainly from the investor tape perspective, they're going to be saying, well, if the discussions are that difficult now, how will they be better later?
Yeah. The investment money isn't going to cover up or solve any of the problems. If anything, it might exacerbate it.
Yeah, and it can
So,
help understand where there's alignment of interests.
yeah, absolutely. So next question then, Stephen, this one's directed to you. You mentioned that sometimes companies do IP without having a wider strategy. Can you explain this a little bit more, and how is IP supposed to fit into a wider strategy?
Yeah, a lot of companies come to us and they say, someone's told us we should get protection for this. Right? And if I ask why, they often don't know the answer. And so that's what I mean by that. I mean, if you have a product, you can use some examples. Nest Labs, for example, is a great case study. So it was founded by ex-Apple engineers. They knew their market. They also knew who their main competitors were. And so in creating their IP, they had in mind the particular products they were launching this year, 2 or 3 years from now. What was the kind of an exit strategy? Who were the competitors, and how are we going to stave off the competitors? Because in the space that they were looking at, thermostats, you have big names like Honeywell and other companies who are very litigious. And so how are we going to address all of these issues? And so from an IP perspective, they put in place a patent portfolio to protect their core products. They also started a portfolio on their future products, and they also started acquiring patents to help stave off attacks by Honeywell, which eventually happened, and they were successful in fending off. So that's what I mean by a strategy. Like, where are you today? Where are you a year from now, 3 years from now? How are these patents going to help you get there? Who are your competitors? Are you in a litigious space or not? What do you need to do to make sure you're ready to face that? And so it's not just I have a piece of technology, check, and I'm done with it. It's basically where am I going on this journey? And as you go from a startup company to a scale up to a large company, multi-billion-dollar company, your IP strategy will change. And it's good to put in place a team at the beginning that can scale in evaluating the IP as the company scales up and matches its needs going forward.
Gotcha. So Brenda, I want to turn this over to you as well. From an investor perspective, how much do you look at IP strategy, or is it as simple as whether their IP is protected?
I mean, it's an important point. I mean, I will, reflect on the fact that I won't name names of companies, but there's something to be said for, there are certain companies that it's really important to be to market first. And, you think about the network effect. There are some companies that are just so advanced in terms of where they are in the marketplace, and they have so many users or subscribers or whatever it may be, that, for them, had they taken the time to do all the upfront work around patents and things and what have you, they have to ask themselves the question, would someone eat their lunch in the meantime, right? And I'm not saying that that's right or wrong, but I'm just saying that's a practical thing that I've seen, companies have to face. I've also seen companies though that have, been on a great trajectory, and then, to Stephen's point, someone's come out of the woodwork and put claim to it, which has been extremely, problematic, right? So I think it's like, if business were easy, we wouldn't be having these panels this morning. But I think my number one thing is, for people to be aware of the potential issues, because I think business is about risk. And if you try and reduce and eliminate every single risk, you'll never get on with your business, right? So it's about understanding what are your risks, which risks are you prepared to accept, which risks are you able to mitigate, and move forward from there.
Yeah, absolutely. You know, I love what you said there. If you spend your entire time mitigating the risk, you're not going to get down to executing and actually doing the stuff that you wanted to do, right? So now on the topic of risk, legal fees can be expensive, especially early on in a business. What recommendations do you have in terms of minimizing the costs? And also, we kind of talked about this a little bit as a follow-up. Since the legal fees are quite expensive, whereas founders might most often start out by bootstrapping, what's a good trade-off point in terms of spending on legal fees, and when should that balance be struck?
I mean, I'll say one comment, and then I'm sure Stephen and Matt have a view. To the extent that you, as the company, can have a general idea of what problem you're trying to solve for before you go in and talk to your legal counsel. And when I say have a general understanding, you don't need to know all the ins and outs of the legalities of it, but just understanding from a business perspective, what's your issue and what are you trying to do and what would be a good outcome for you. Because otherwise it's like going into a restaurant, and I know it's been a while since we all been in one, so we probably forget now, but it's like going into a restaurant and telling the waiter that you're hungry, but not having thought, well, are you really hungry, a little bit hungry? Are you a vegan? Are you not a vegan? Like, what's your price point? I mean, you go and talk to a waiter. I mean, that waiter's just not positioned to help you. But if you can do some homework, and so part of that homework is talking to your CEO network, talking to your board members, talking to colleagues to kind of start to shape up your thinking a little bit, so that when you go in, you've got sort of a narrative to share with your legal counsel.
Yeah,
I think that's what, sorry, go ahead, Steve.
So I was going to say, on the patent side, the good news on the legal fees is that the patent process is extremely slow. And I think from a perspective of a startup company, that's actually in their favor, because it does allow the expenses to drag out over a number of years. So on your roadmap, you can actually figure out where I need to be and what I need to raise by certain points. And so it's good to get a budget in place with the IP, for example, and know when the expenses will be and what those expenses will be at the particular point in times. And there are a lot of programs, probably beyond the scope of here, but there are programs available for to helping with funding for IP at various stages. But it depends a lot on where the companies are. Some programmings will require the companies to be at, ready to go to market stages and things like that. But I would definitely engage with an accounting firm or something like that who is in tune to all these kind of programs, and see where you fit and what can help you with that.
Matt, did you have something to add on?
Oh, I was just going to say, I mean, if you have good legal counsel, trusted legal counsel, we will help you keep your legal fees in check. I know it sounds counterintuitive, but there's a type of shareholders agreement that you need when you're a brand new business, and there's a type of shareholders agreement that you need when you're doing a Series A or a Series F, for that matter. And they're not the same. And the one that when you have, we did a transaction not so long ago where Samsung and Intel were investing in one of our clients. They're doing a Series A, and the company spent, I would say, upwards of $75,000 negotiating not just the shareholders agreement, but the other investment documents as well. But they were getting a significant amount of money, and it was going to shape the way their company looked for the next decade. And so that was, that there's that scope there, but that's not the same scope as when you're starting up, and you don't need that level of negotiation and advice. And so good legal counsel will say, you don't need this, you can live with this. And if you say, listen, my budget is X, I mean, obviously there is going to be some cost. So you may say your budget's X, and they may say, listen, like that's not going to get you very far. But if you say my budget's X, we can have a conversation with you and say, okay, well, usually we charge this. For that, we can do this, and it's not going to cover all your needs, but it's going to help you. It's better than nothing type of thing. And so, have those conversations with your legal counsel, use their expertise, and have those conversations. I think that goes with all your advisors as well. You can have the same, an accountant is also, a good legal advisor. You can have that conversation with them about, okay, what should I be doing now versus later? And, good legal counsel, good advisors will help you control your costs because, to be honest, me doing your shareholders agreement when you've just started up, that's I mean, do I want that business? Yes, but the payoff is that for me is that when you do your Series A down the road and I get to be your legal counsel and we're charging you those $75,000 in fees, which everybody's happy to pay and we're happy to receive, but those are the relationships we're building towards.
Mm-hmm. Awesome. So we have about 40 seconds left or so. So thank you for everybody who submitted questions. We're not going to get through all of them. So I will copy them and also send them off to our panelists for them to jot some quick notes afterwards as well. But I think this last one is a really good one to cap the conversation off. What type of advisors, in perhaps like 20-second responses, what type of advisors do you recommend for founders to avoid making mistakes during hires, fundraising, IP strategy, etc., and how can they engage them? Of course, we know somebody like Steven, somebody like Matt, and somebody in Brenda would be excellent advisors for that. Do you have any additional thoughts before we end off the session?
I actually have a call with my legal counsel at 11:30, so I'm glad we're finishing at 11:30. But I would say, the war for talent is really on. I mean, pick up any newspaper, go to any blog. So have someone who really understands the whole talent attraction, retention piece.
Yeah, and I guess my 20-second bit on that is find somebody who can be your mentor, somebody who's gone through this before, because that person they can tell you where they made mistakes. They can introduce you to the right people. And the mentor can be, somebody that you've met in the business community. It can be a lawyer, it can be whomever, but somebody who can give you that unvarnished advice and give you some guidance.
I would echo that. I mean, there's a lot of great people who have gone through the process, formed successful companies, had successful exit strategies, and are now just out there providing their advice on companies in their particular space that they like. And if you can find those people, they're golden.
Mm-hmm. Amazing. All right, so we're at time. Thank you so much, Brenda. Thank you so much, Steven. Thank you so much, Matt, for being here. I'll copy the additional questions and send them off to you if you have additional thoughts. Thank you, everybody, for being here as well, for joining this session. Please take a look at our training and webinars and workshops site to look at further scale-up sessions that we have coming up, and we look forward to seeing you all at those. Big round of applause for our panelists. Thank you for taking the time, and I hope you enjoy the rest of your day. And until next time, we'll see you again. Bye now.
Thanks, John.
Thank you.